BJP leader Ashwini Upadhyay had moved Supreme Court in a public interest litigation where he was praying for directions to be issued to the Election Commission so that only name, age, qualifications in the picture of a contesting candidate is mentioned on the electronic voting machine and not the party symbol. However, Chief Justice of India S.A. Bobde-led bench did not issue notice in the matter and instead asked the petitioner to serve a copy of this petition on Attorney General for India K.K. Venugopal. This matter will be taken up next week. Senior advocate Vikas Singh, representing Upadhyay, stated that he has checked up the law prevalent in Brazil and that the similar law is in place where only the picture and age, qualification and the name of the contesting candidates is mentioned on the EVM machine and not the party symbol in this case. Supreme Court of India today, while hearing a petition seeking the implementation of pre-litigation mediation in India or a formulation of a standard operating protocol to put the pre-litigation mediation aspect in force in India, asked Solicitor-General Tushar Mehta that it was earlier apprised that a law would be soon passed by the Parliament which would give pre-litigation mediation a force of law. To this, Solicitor General Tushar Mehta has now sought a time of 3 to 4 days in which he would seek instructions on this law which is set to be passed by the Parliament and apprise the court about the same. Chief Justice of India S.A. Bobde, in a question to Senior Advocate Shoma Chakraborty appearing for the petitioner, stated that the resolutions passed by the state assemblies only portray the opinion of the state house towards the legislation passed by the central government and that it is only a request to the central government to abrogate that particular law. However, those resolutions do not have any force of law and neither it was asking anyone to disobey the law of the Parliament. A Chief Justice of India S.A. Bobde-led bench today heard a petition by Samta Andolan Samiti challenging the legislative competence of diverse state assemblies in adopting resolutions against central statutes like the Citizenship Amendment Act and farm laws, which fall under the Union list of the 7th schedule. The petition says that the resolutions passed by states like Rajasthan, Kerala, Punjab and West Bengal had infringed the fundamental rights of all the citizens. The petitioner in this case has now been asked to do some further research on the aspect of immunity of the state legislature, and this matter will be again taken up next week. Well, today was the day 5 of the Maratha Reservation hearing where a 5-judge constitution bench headed by Justice Ashok Bhushan was hearing a batch of petitions challenging the validity of the Maharashtra State SEBC Act, wherein educational and employment opportunities were set to be given to the Marathas on quota basis. I'm saying that these have to be looked into when you make law. When they made a law for reservations, more than 50%, this provision does not say that the limit will be stuck at 50%. Will the balance be struck by as a limit not to be breached or by the state on individual analysis within state on nature of the job seat? Will it be struck by the court that I cannot breach 50%? Said Senior Advocate Mukul Rohatgi. Senior Advocate Mukul Rohatgi also said that he was not saying that the Indira Sawhney judgment is wrong or that it should be thrown in the dustbin. But instead, he said that a considerable time of 30 years has passed since the Indira Sawhney judgment and the situations and the populations have changed and the numbers of backward class persons have also increased. The Maratha Reservation hearing will again continue next week. Well, that's all from Supreme Court today. Do stay tuned for Supreme Court today on Monday as well. And don't forget to like and share barandbench.com.